Hi, I'm Ian Linklip, the Consumer Insider. I'm a consumer protection attorney from Southfield, Michigan, and I love my job. For 25 years, I've been representing consumers in their disputes with car dealers, credit bureaus, and debt collectors. And each week, I bring you the inside scoop on how it is that these businesses use documents in the court systems to cheat and bully consumers. With a little luck, we're going to teach you how it is that you can resist and be heard when you're dealing with these companies. And let's get started. Today is part 2 of our series on writing credit disputes. And today I want to talk to you about some of the pitfalls of credit disputes and how it is that you go about writing them. In the next part of this series, we're actually going to go through some examples and see some real life sample documents and letters so you have an idea how this works. So let's get started with credit disputes part 2. So the first thing to know about writing your credit dispute is your target audience and who it is that's going to be reading this letter and what they're going to do with it. So if you keep these things in mind, they're going to help you as you draft these letters and make sure that they're written appropriately and they do the job that you need them to do. So the first thing to know is that the first person to see this letter is going to be somebody at a credit reporting agency who is working in a boiler room with dozens, perhaps hundreds of other people doing the exact same thing. They're going to be looking through these letters, scanning them, trying to understand what the dispute is that you're making, and then they're going to take that dispute, the whole dispute, and they're going to reduce it down to a 3-digit code. And that 3-digit code is called a dispute code. So once they have reduced this to this 3-digit dispute code, that 3-digit dispute code is going to get transmitted through the internet over to the creditor, the data furnisher who provided the information to the bureau, and they're going to respond back with a response code. So to keep in mind what this means for your letter is you want to make sure that as you write this dispute, that this dispute is clear, concise, gets to the point, and nobody can mistake what it is that you are contesting on this report. And remember, you're dealing with people who are receiving hundreds of these letters and reviewing hundreds of these letters every day. They've got these letters and they need to just reduce it down to a 3-digit code and spit it out because they got work quotas that they need to meet. And if your letter goes on and on and on and does not get to the point and does not convey it clearly, you're going to have a problem and they won't get it right and you won't get the item removed. And we want to make sure that we give your letter the very best chance of success with the credit bureaus because you don't want to have to take the next step. And the next step is where the letter gets its next vetting, which is with potentially a jury. If you have written your letter several times and you've been unable to get the result that you want, you're going to have that next step, and that next step is going to be filing a lawsuit under the Fair Credit Reporting Act. And once the juror gets it, you want to make sure that this juror, whose entire job at that moment, when they're looking at your letter, is to determine whether the bureau has done their job, you want to make sure that that juror comes to the same conclusion that everybody else does, which is there's no way that anybody could have concluded that this item needed to stay on the report. So our test in the office is for these letters to figure out if we've done a good job for our clients is when we're reading through them, would a reasonable person within a matter of 30 seconds or more conclude anything other than this item needs to be removed? And you can do this test yourself at home, and the way that you do this is you find somebody who doesn't know about the problem that you're having, somebody that you trust who will give this a couple of minutes time and look over your letter and tell you whether or not they have come to the conclusion that this item does not belong on your report. And so you're going to vet this letter with them and let them help you understand whether or not you have done that job appropriately. And again, in the next part of our series, we're going to give you some examples and show you how we do this in our office. And certainly, if you've got some other suggestions, feel free to leave them below in the comment section so that we can all benefit from that. The letters have to be out there and readable by both of these audiences, the person who's receiving it, probably somebody in India, and then a juror, somebody who's just like you or me, and it's got to satisfy that. So, general guidelines for these letters. Number 1, be truthful. Always be truthful. You can't write a dispute about write a letter dispute about an item that actually belongs on your report. As soon as you start writing to try and remove items that are incorrect, you are you're watering down the value of your bona fide disputes, and it makes you out to be a liar. You don't want to be shown to be a liar either to the bureaus or to the jurors. So apart from that, there are federal laws that limit how much, limit the kinds of things that you can dispute. You can certainly always dispute items that don't belong on the report, but if you're disputing items that are negative and accurate, federal law is going to say you should not be disputing those. Next, be direct with your dispute. Be very clear about what it is that you want them to do, and you want to make sure that you've got adequate support. So now let's go through some very specific formulaic guidelines on how you're going to write this. First, make sure that you give a very direct explanation of what the problem is. So you know when you get your report back and you're reviewing it, you are going to be looking at maybe 10, 15, or 20 pages of information about you, your credit history, your identifiers. So in this document of all this information, it's not good enough to just say my credit report is wrong. That is notoriously what the credit repair services will do, is they'll send these very generic disputes saying something like, oh, I've received my credit report and it's wrong, please fix it. Not good enough. This is not good enough. You want to be able to direct the credit reporting agency to the specific information on that report that's inaccurate. So for instance, if your name is incorrect, you want to point them to the place where that occurs and the information that's wrong. So for me, if they had put me down as Tom Linklip, it's not my name. So I would say, dear Mr. Credit Reporting Agency, on page 1, you have me listed as Tom Linklip. So I've identified the specific piece of information, I pointed them to the page, and then I'm going to attach that page to the dispute letter and highlight or circle that information so that you are directing the dispute handler right to it. So you want to give a clear direction to them, and that same thing is true of information about credit accounts. So for instance, if they say to me, you have an account with Bank of America, I can direct them. On page 6, you say that I have an account with Bank of America that's now charged off. And now I've directed them to that, I've circled it, I've highlighted it, and everybody knows what we're talking about. So we've identified the problem. Second, explain in 50 words or less why it's wrong. You've already told them what's wrong, now we're going to tell them why it's wrong. And the explanation can be as simple as, this is not my account. If you know whose account it is, you may want to direct them to that. For instance, there is a well-known problem where creditors make mistakes in relation to spouses, where one spouse is an authorized user on a card but is not responsible for that card. And there's a special code to describe that situation. It's called the ECOA code. We'll talk about that in another podcast. But I want to say in that, hey, you've identified me as being a jointly responsible for this account. This is not correct. I am only an authorized user. I am not responsible for the account. So there it is. There's an explanation, 50 words or less, about why it is that that information on the report is not correct. If it's an identity theft account, you may want to say something like, this is an identity theft account. I did not open it. I do not know who did, but please take it off my report. So you're explaining why it is that this account doesn't belong on the report. And the same thing can go for an inquiry, a phone number, an email address. If you know that it's not yours, tell them why it's not yours. Tell them whose you think it might be if you know. Give them as much information as you can, but do it concisely. Next, you want to include with your dispute letter any documents that are going to support your position. So for instance, going back to the example that we used before, if I've disputed an account that is my wife's account, I might include the cover page to all of the billing statements that are there, saying you can see from these billing statements that she is the only one who's being billed for this account. So you want to make sure that you're including those documents. If it's an identity theft account and you filed a police report, attach the police report. If you have filed an FTC affidavit, include the affidavit. Include the supporting documents, and in your letter then, refer them to the supporting documents and tell them why it supports your position. You want to make sure that you identify these in the letter, because It is not uncommon in large mailrooms that a letter and a document become separated, and all of a sudden nobody knows where the documents are. So you want to refer to them in the letter to make sure that they're looking for them, and that if they become separated, they can look for them and find them and put them back together again. It also is a quick reference because the person who's receiving this letter at the credit reporting agency, they are not going to know why it is that this document supports your dispute or be able to match specific documents with a specific dispute, especially if you have multiple things that you're disputing in the letter. You want to make sure that they attach the right document to the right information that you're disputing. So it's so important that you do this. You got to let them know what's in there. And ultimately, the fact that you've identified those documents, if for some reason they get separated and the credit reporting agency doesn't look at those documents, you'll have proof that you sent them because you've identified them and you kept copies of those. Okay, so next, in some limited circumstances, we ask our clients to provide exemplars of their handwriting or include identification. This is really important if you're having a bitter dispute about an identity theft account and you need to show that it's not your handwriting that is signed. In some instances, not a lot, but in some instances, our clients will do their own investigations before they come to us, and that investigation will turn up the source documents. In other words, they may write to the creditor and say, hey, this isn't my account. The creditor sends back a promissory note or some other document that purports to have the consumer's signature on it. If the consumer has it, if you have that document showing the signature and it's clearly not your signature or it's somebody else entirely, you want to be able to say, hey, I sent them handwriting samples and a copy of the signature that the creditor is relying on, and they still verified it. So if you have a copy of the signatures that you can use to compare with your own, send in an exemplar, 5 copies of your signature on a single piece of paper, send it back along with the dispute and the disputed signatures, and that may help. And you can also include signatures from identification you have, like things like state-issued ID. Those will help support your dispute. Okay, so lastly, a concern about the tone of your letter. You do want to make sure that you do not go on too long with the dispute. We see this all the time from consumers who have worked on dispute letters on their own, and their letters may go on for pages when the dispute is actually quite simple. It's an identity theft account, and the consumer wants to tell the whole story of the identity theft. You don't need that. What you need to do is say, my identity has been stolen, here's the police report, or here's the identity theft affidavit, or here's the exemplars of my handwriting and to compare it to the signature that they've got. It's not me, I didn't do it. And the burden's going to shift over to the furnisher, the creditor whose account that is, to make sure that they've got the right person. Telling the story of the identity theft isn't going to help you to say how long you've been fighting it or who you've written disputes for. The important part is that you get that dispute out there clearly and concisely with the supporting documentation. So that's what you're going to need to put in that letter. Is you want to make sure that you get all that information. Now, there's some things that you want in return from the credit reporting agency when you send this letter off to them. You want to ask them to please forward any documents that you've sent to them onto the credit furnisher. That's the person who provided the bad information in the first instance. Because they don't always do this, and maybe 5 years ago they didn't have the capability of doing this, but now they have that. That's built into their systems that they can forward that information onto the data furnishers. So you can ask for them, hey, please send over the relevant documentation that I've sent to you so that the furnisher has it as well. And then you want to ask that the agency send a corrected copy of your report to anybody who's seen that report within the preceding 6 months. You have a right to ask for that, and that right is also extends even longer for employment circumstances. So if your credit report has been used for an employment background check of some sort and you've had a problem with that for 2 years, for a 2-year reach back, if somebody's looked at that report, you can have the Bureau send a corrected copy of the report. And that may be important for you if you have been denied a security clearance or a promotion or a pay rate increase. that is still on the table and you can go back and get. So just remember that you can ask for that. And it's a very important thing to make sure that you got those creditors properly updated about the information in your report. And lastly, you want to provide them with good contact information for you, including a phone number and an email address where they can reach back to you and ask for more information if they need it. And you want to offer that up. You want to let them know that if they have a problem with the documentation that you sent, they can reach back to you and you will respond to them and help them with that, with any information that would resolve the question of whether or not the item belongs on your report or should be deleted from the report or modified in some way or another. Those are the important things that you're going to need to do with these letters. Now, that's all for this week's installment. Next week, we're going to show you some real live examples of how it is that you can correct these reports and what they look like when they're finally assembled. And when this series is done, we are going to have copies of our templates from the office. We're going to have those up on our website along with some of the diagnostic tools that we use that help you organize this information so that you can track when you're disputing them and what needs to be disputed and who you're disputing to. So you've got a pretty, so you'll have a package of information that you can use to write these disputes. That's it for today. I'm Ian Linklip, the Consumer Insider. You can find me on the web at www.consumerlawyers.com. You can find me on Twitter at MIConsumerLaw, and you can find me on Facebook at the Michigan Consumer Law Center. If you have any questions for me about anything that was in this podcast, or you have something that you'd like me to talk about, you can either put it in a comment below, or you can send it to me in an email at podcast@consumerlawyers.com. And I will do my very best to answer any questions that you've got or address any of the topics that you want seen on the podcast. You can find me at consumerlawyers.com. That's all for today. Thanks for watching.